how does that materiality determination work there. So what we've seen is that a lot of components in the SEC climate rule are depending on that, let's quotation mark, a traditional financial materiality determination. I'm saying that because with the kind of emergence of sustainability reporting, we've seen some, slightly different sustainability related materiality in definitions also. So yeah, the concept of double materiality, where we look at, yes, that financially accounting kind of clear financial materiality concept, but we also look at something else, which is impact materiality. And that is different because it's not saying what are the impacts on the business, it's saying how is the business impacting the world. Now, if you do global reporting initiative, GRI reporting, their materiality assessment is impact materiality. How is your business affecting the world? So if you're doing all that work and in that you find that climate and GHG are not material, you're like, well, right, we don't have to do that. That's a different way of looking at materiality. So for the sake of the SEC rule, what are we looking at from a materiality point of view? What's the definition we're using?
Yeah, the SEC was very clear, and I think there's a litigation overlay to this as well. We're using just traditional U.S. Supreme Court definition of materiality, a substantial likelihood that a reasonable investor, blah, blah, blah. I won't read what's on the slide for you, but this is the same materiality determination that companies have been making under, SEC reporting for years and years and years. It's the standard sort of formulation of materiality, not impact materiality, but financial immateriality, the effect on the registrant. Now, that doesn't mean that you're entirely out of the woods. And I think the title of this webinar is instructive, right? Because it can be very tricky to apply that in practice. And there are a few different ways that your materiality assessment can be, second guess post facto. At the sort of highest level, there's SEC enforcement actions. I mean, those rest on the SEC disagreeing with a company's conclusion often that something is material or immaterial. There are comment letters, even under the sort of prior regime of SEC rules before these climate rules were adopted. The SEC was very active in putting out comment letters on climate-related matters and really sort of pressure testing companies to show their work on their materiality determinations, and going 2, 3, even 4 rounds of comment letters, really pushing on, is this really not material? Until effectively, I think most companies sort of gave in and concluded, okay, fine, we will put some information in there. Shareholder lawsuits, those often rest on whether something is material or not, or whether there was a material omission or not. Right now in the US, as a very litigious society, it's actually remarkable how, relatively speaking, little those sorts of suits have taken off. But if there is sort of the prospect of those becoming more profitable, I do think the plaintiff bar will be particularly interested in really drawing a line on, materiality determinations in the reporting and bringing suits based on that. Even separate from sort of the traditional plaintiff bar, I think you could also see, activist and oriented investors bringing suits kind of similar to some of the suits that are brought in Europe, in the Netherlands, et cetera. And just shareholder engagement. I mean, you can make a materiality determination, determine something's not material, and thus you're not going to report on it. But if one of your big investors is sitting across from you in an engagement meeting and explaining, actually, no, we do think this is interesting and we want to know about it, it's a bit of a pressure test to your materiality determination. So it's traditional materiality, but as we have found with other definitions, other uses of that traditional notion, it can be asked about post facto.
So there's a lot happening around that materiality determination. There's a lot of components that are expressly tied to materiality. So you really need to work your way through some of those components, do that materiality determination to make sure you fully understand that. You already raised, I think throughout the webinar, we raised a few questions here, but we've seen that there's a lot of questions coming, I think your way, my way, around that materiality, application to the SEC climate rule. Now, the first one really touched upon it, kind of, you've done your broad-based materiality assessment. Out of that, climate, GHG, they were not found to be material. Do I have to report on the SEC climate rule? Well, we need to look at what are all the components of the rule. That's one, but also go back then. How have you done that materiality assessment? So what really did you do there? Was it a GRI impact materiality assessment? You probably have to do that financial materiality assessment again, or have you really look at the process and really make sure that you go over it again. What are your thoughts on that if people ask that question?
Yeah, 100%. As you say, not everything is materiality qualified. You still need to give a lot of your governance disclosures, for example, even if you don't consider them material. I would also say that, if you have done a materiality assessment, there are some things in the SEC rules which essentially instruct you to consider certain options, certain items, and certain factors in assessing the materiality. I'm guessing those you probably didn't do that materiality assessment before that rule, and if you're ever asked about your materiality assessment post facto by the SEC, you'll want to be able to point to the fact that you considered what they told you to consider. So be sure to kind of refresh it from time to time. I mean, materiality is not static.
I think that's a really good point. It's something we always emphasize with doing a materiality assessment is be really clear about what you're doing. Document every step, every consideration, methodology, rationale, approach, so that later when people ask that question, how did you get to that determination? Yeah, whether it's right or wrong, but at least here's the process, how we got there. And I think that's a key component we see both, from a more traditional kind of perspective around materiality, but also anything sustainability relating. Document what you're doing. That will help you a lot if you can explain the process, how you got there.
100%.
Then I think we touched upon this one as well, but really quickly. So someone's like, my business is very low GHG scope 1 and 2 emissions, so it's not material, right? You can move on now. What does that mean?
I think it's indicative. I wouldn't say it means that you're totally out of the woods yet. One thing is you want to be able to document your considerations. So that means there's a process, even if you think you probably know what the answer is going to be at the end. The SEC also says you should be considering if there's foreign or state law kind of regulatory burdens that are related to climate emissions, and whether it's, necessary for an investor to understand your progress towards a goal. That should be a factor that weighs in your materiality assessment. So you may have a very low GHG emissions, but if you have a goal and you need to report your progress, that may lead you to think it is material. The other kind of macro point I'd mention here is that if you are going to be disclosing your GHG emissions pursuant to California or pursuant to CSRD, there may be a bit of a thumb on the scale on the factual reality is, look, we're already doing this reporting. It's out there in the world. Why bother taking the risk of being, second guessed about the consideration of materiality? Maybe we lean towards doing it, but I still think you want to have a rigorous process.
But that leads into question 3, which is a really good bridge to that, is my business is already doing GHG accounting, voluntary TCFD reporting. We've been doing that for a long time. I think in doing that, my investors now kind of expect this information. So the expectation, since I've been doing this, does that expectation in and of itself make it kind of material in that sense? Like you said, maybe if you do a pure de facto, materiality assessment, you find that, well, by doing this, it's not material, but I've been doing this for some years. My investor sitting is across from me saying, well, you might think it's not material, but I think it is. Where does that land?
I guess you need to assess whether they're a reasonable investor or not. No, I think it is a relevant factor to consider. And, frankly, I think this also sort of speaks to some of the other questions too, like number 4, right? Like I may have very high GHG emissions. Does it make it automatically material? I don't think anything makes it automatically material, right? I mean, this is a facts and circumstances, based inquiry. And, how you assess materiality may differ depending on which item you're talking about. I mean, if you look at question 6, who at my company needs to decide what's material? Sometimes it'll be legal people. There's some materiality elements of the SX portion that'll likely involve your accounting team. You talked about the material supply chain disclosures. That could be someone from your supply chain function could be involved. I think you need to be very flexible in really following the command of materiality to assess all facts and circumstances. You need to do it in a flexible manner.
Yeah, and I think that goes to point 5 as well, where we're looking at that climate-related financial risk component. And we've seen companies, my board and management have looked at our risk. We have a risk process. There's nothing there. There's nothing to disclose. There's nothing material. But the question often there is like, have you actually gone through a full value chain focused on climate? Risk assessment. Have you actually done the work? Are you relying on more traditional, risk management? You haven't actually asked the question there. So I think all these things go back to don't assume, do the work, go through it, check and double check, document what you're doing, and really look at what does the SEC rule really require. So I think that, a lot of these questions kind of have a pretty similar answer there. So that takes us then to the final kind of thing component there, which we'll look at